In 1996, Bill Gates said, "Content is king." And boy, was he right. 3 decades later, it still occupies the throne. For lawyers, law firms, and companies serving the legal industry, content marketing and thought leadership marketing are a must if they want to build their books of business or increase their revenues. Hi, I'm Wayne Pollock. I'm a former AM Law 50 senior associate who discovered the world of content marketing and thought leadership marketing and hasn't looked back. In each episode of this podcast, I interview lawyers and legal industry in-house marketers who are doing big things with their content marketing and thought leadership marketing. This is Legally Contented. Welcome to episode number 12 of Legally Contented. I'm your host, Wayne Pollock. These days, there is no shortage of C-suite executives at law firms, both small and large. Chief Executive Officer, Chief Operating Officer, Chief Client Officer, Chief Technology Officer. It is not uncommon for there to be numerous C-suite executives at a particular law firm. But what about Chief Content Officer? Well, the name of this podcast is Legally Contented, so you know I was going to track down a law firm's Chief Content Officer. In this episode, I speak with Richard Meneghello, who is Chief Content Officer at Fisher Phillips. The firm is an AM Law 200 firm. It has about $280 million in revenue and has a little bit more than 400 attorneys. In this episode, Rich and I discuss what he does in his role as a Chief Content Officer at an AM Law 200 firm. We talk about what COVID-19 taught Fisher Phillips and law firms generally about the value of content marketing and thought leadership marketing content. We talk about the role planning should play in a law firm's content marketing efforts. We talk about why it's okay for law firms to fail when testing new content marketing initiatives. We talk about why lawyers should take positions in their marketing and business development content. We discuss what a culture of content creation looks like at a law firm and how law firms should handle breaking news regarding legal developments. As far as I know, and feel free to correct me, there aren't any other chief content officers at law firms in the U.S. So talking with Rich was a treat for me, and I hope you'll find it to be a treat for you too. Here's my conversation with Rich. Rich Meneghello, welcome to Legally Contented. Please introduce yourself and tell us all how you got to be where you are today.
Yeah, hey, thanks, Wayne. So Rich Meneghello, I'm the Chief Content Officer at Fisher Phillips. We're a national law firm that focuses on workplace law, representing employers in all aspects of labor and employment law. And it's sort of a long, strange road that led me to where I am today. But with many folks, I think, that you've probably worked with, and like yourself, started out in the law firm world as an associate attorney. I was doing labor and employment law. And ended up, I've always had a passion for writing, creative writing, and I was fortunate enough in our firm, Fisher Phillips, to have a great mentor a guy by the name of Mike Mitchell, who was in charge of writing our firm newsletters back in the day when we actually printed out actual physical newsletters and mailed them to people via snail mail. And I used to write for him a bunch. And long story short, just realized that I was sort of after, almost 20 years of practicing law, that I was ready for a change. So that's sort of the big picture version, but I don't know how in detail you want to get.
Well, obviously, based on the focus of this podcast, I want to dive all over your role as Chief Content Officer, but we have to take a step back, and I want to hear about your legal career and your path to where you are today. We can, of course, skip graduating from one of the greatest universities in the world, Syracuse University.
Go Orange.
Oh, by the way, I graduated 9 years after you did from Syracuse. We can skip that to not bore people and scare them away. But talk to me. You graduate Georgia State School of Law in 1996. Talk to me a little bit about your legal career. I know you were out on your own. You actually ran a firm for a little bit. So talk to me about post-law school to Fisher Phillips, how you got there and how you worked up the ranks at Fisher Phillips.
Yeah, sure. Well, Yeah, I was never on my own per se. I was with a great group of people, but just happened to have my name on the wall. I landed in a really good spot. I realized in law school that I wanted to do labor and employment law. Just had great professors, great work experiences, really guided me in that area. So when I moved to Portland, I luckily pretty soon after I started practicing found a home with a one of the preeminent labor and employment attorneys in the city at the time, a woman by the name of Corbett Gordon, who had just opened up her own shop. And doing defense work, back then it was, I guess, maybe a little bit more common. We had a small shop of about 6 or 7 attorneys. We were representing some of the largest employers in the nation when it came to their Oregon-related workplace matters. And this is back before any of the big boutique firms, national big boutique firms, were in town. So, yeah, did that, cut my teeth under her. She gave me incredible guidance and a lot of confidence in, getting creative in terms of litigating cases and my approach to the law. So, did that. We really gelled well. We formed a really great team. And so after I'd say about 5 or 6 years of working with her, she asked me to be a partner in her firm. So we went from Corbett Gordon Associates to Gordon Meneghello. But yeah, as you saw from my LinkedIn profile, that my name was only on the wall for about 9 months before we joined Fisher Phillips.
Okay, so there we go. So it sounds like you were acquired, or you were brought on to Fisher
Yeah.
Phillips as
So
a
at the
group.
time, again, there were no, for those who know workplace law, will recognize sort of the big four: Littler Mendelson, Ogletree Deakins, Jackson Lewis, Fisher Phillips. At the time, none of those firms existed in Portland. So for a variety of reasons, she was sort of at the tail end of her career. I was on the beginning stages of my career. So we decided, you know what, instead of just, we sort of saw the writing on the wall in terms of some of these national firms and how they were going to have a footprint in Oregon. So we talked to a lot of different groups, but joined Fisher Phillips at the time. I think at the time we were the 10th or 11th office. We were probably, you know, in the low hundreds in terms of number attorney headcount at that time. And now our firm has 500 attorneys and 36 or 38 offices. So we got in sort of at the beginning, but yeah, that was in 2002, so 20 years ago now.
So obviously today you're chief content
Yeah.
officer. What were you doing personally for your marketing and business development back 20 years ago, and even before you joined Fisher Phillips? Were you cognizant as a young partner about the need to build a book of business? And if so, what were you doing to build that book?
Wow. So, way back then, pre Fisher Phillips, definitely was aware of how, bringing in clients is a lifeblood of the firm. But, when I was that junior, our firm did not have um, any sort of metrics or requirements for bringing in business. And that quickly changed when I joined Fisher Phillips. We're a very entrepreneurial law firm. People definitely are encouraged and incentivized to bring in your own book of business. So I didn't really have that. I didn't have a marketing gene per se. I think before I joined Fisher Phillips, I had the creative side. I really liked creativity when it came to ways of thinking about the law, and I did like to write things for a small little mini newsletter we had, but it was more for fun, I think, than for anything. And Fisher Phillips helped me sort of merge the idea that you can get creative, you can do writing, and that will help you build your book of business. So it sort of all came together when I joined the firm 20 years ago.
And walk us through your transition from your typical AmLaw 200, or maybe not at that time AmLaw 200, but to present day AmLaw 200 partner. Then you became regional managing partner. But then a couple years ago, all of a sudden you become publications partner. And I'm curious where that pivot, how it happened.
Yeah, yeah. Well, it was a slow road and a long time coming, and then it just sort of happened overnight. But the slow road coming up to it, I really always enjoyed creative writing, and so I very often, it's back in our firm's history, wrote for our newsletters. This is before we had any sort of content you'd put online even. Um, and I was again encouraged by our the partner at the time named Mike Mitchell in New Orleans, who was in charge of putting together our newsletters once a month on the side, right? This is just something he did on the side. Um, he encouraged me to have fun with it and not only write sort of the annual review about workplace law, but do it in a fun way, or come up with creative ideas for a new we'd read about a story in some sort of publication and want to give advice to employers about what it meant for them. So I always had this encouragement to write in that area. And then the digital age came along and we then started, posting some of the stuff online. But gosh, back then we were maybe writing 3 or 4 pieces a month, right? I mean, it was really a lot different than it was today. And so we recognized, though, that there was this hole and that we were falling behind our competitors when it came to content creation. And that happened right at the time where, in my career, at that time I was litigating. I had a very heavy docket of all sorts of cases in the workplace realm, and was also managing our firm's office as our regional managing partner. And I have a very specific memory of a day in March 2016. And for attorney-client privilege, I can tell you the name of the case I was working on. But I was prepping for a deposition, reviewing an outline that an associate created for me, and it just hit me like a ton of bricks. Like, I'm not enjoying this anymore. I haven't been enjoying this for a while. It wasn't that I was burnt out for it. It wasn't that I had sustained any losses or had lost clients or anything like that. It was just, man, the routine of doing the same thing every day and walking into a mediation, and we all know where this case is going to settle at 4 o'clock in the afternoon. Why are we spending 8 hours to get there? And the silly arguments that we raised at depositions where I know the objections you're going to raise and here's how I'm going to respond, and all that sort of showmanship. I was just sick of it. And it all hit me just again on this one day. And I'd heard that our firm was thinking about hiring somebody to manage the publications, as our combination of Mike Mitchell at the time wanting to retire and our firm realizing we were behind our competitors. And so I just reached out to a few people in our firm and said, hey, what if I threw my hat in the ring here? What do you think? And I'm very grateful for the fact that a combination of people, our chief marketing officer at the time, a guy by the name of Kevin Sullivan, the head of our development committee, a guy named Jim McDonald, and our firm's managing chairman, Roger Quillen, all enthusiastically supported me in that. And I leapt in with both feet and haven't looked back since.
For those, 14, 15 years between you joining Fisher Phillips and you becoming publications partner, how would you say your content creation efforts that you were obviously juggling as a full-time partner and a full-time attorney, how did they compare to your peers? Was there a culture of content creation even back then when there wasn't as much digital communications? Were you the black swan? Obviously, at least one of your colleagues had encouraged you to write and comment on the law, but I'm curious where Rich fit in versus his peers in terms of content creation toward the book of business building that partners are expected to do.
Yeah, I definitely stood out, and I'm not tooting my own horn here. I'm saying it I think some people thought I was an oddball, right? I mean, because the writing was not something that was necessarily encouraged, and it was seen as a thing that people can do, but it wasn't seen as a mainstay or really a need, and so there wasn't a huge culture there of writing. Our firm was very active in marketing, and I think back then it was mostly speaking engagements, attending conferences, showing up at local HR meetings, being parts of boards. All your typical marketing stuff, I think, was highly encouraged, but I don't think there was really a vision at the firm at the time in terms of what writing could do for your career. So I was definitely an oddball when it came to that, and but I think it was more, our firm really recognized the value of it from the sense that our clients are getting things from other firms that they're not getting from us, so we need to keep up with them, as opposed to the real vision. And I don't think I had the vision at the time I took this role of how it could really enable and benefit our marketing efforts. I was probably really limited. I'd love to interview myself 6 years from now, 6 years ago, to imagine what I thought about what this position could be, so much as it was just sort of supplementing on the side our writing endeavors, as opposed to really being a marketing machine that it's turned out to be.
It's funny. When I was young, I used to go to a dentist that would give out those little wind-up chattering teeth where you wind them up and you put them on a desk and they just start chattering. That is how I view content marketing and thought leadership marketing, in terms of once you get your content out there, it's out there to advocate for you, to sell for you, to market for you. And the irony is that the partners who 15, 20 years ago looked at you, Rich, and said, what the hell is this guy doing? They were going to occasional conferences. Maybe they were occasionally writing once a quarter or every couple, a couple times a year for a publication. But what you perhaps didn't realize, but you did really, is that content is always on 24/7, 365 as an advocate for you, as a marketer for you, as a business developer for you. Every webinar is like a speaking engagement. And when you record it and it's replayed and it lives on the website, it lives on the internet, it's a speaking engagement that's given multiple times a day, a week, a year, whatever. So I think it's so ironic that the more classic rainmaker, the old-time rainmaker who looked at in-person communications as the key to growing a book of business, that certainly still has merit this very day, today, as we're recording it. But it's amazing to me to look at the parallels between content marketing and thought leadership marketing as it exists today and the old school business development and marketing, and see how it's an evolution. It's just a different way of attacking the same kind of task, which is showing would-be clients and maybe would-be referral sources that you are knowledgeable and wise about the area of law you practice, and that you should be the one they call when they have an issue that falls within the area of law that you practice.
And it's such a great point. And I think back to some of the sticking points or some of the concerns that some of these old school, marketers who, again, are incredible in their own right and have great books of business and built them in ways that are, your classic mid 20th century things, probably not much different than how they were taught, back in the 60s and 70s or whatever it was. Some of the concerns they had were that very thing, that content lives and is always going to be there, because they were afraid of how it could be used against them. A lot of people, I remember saying, the thing of a speech is you could say whatever you want and it could be sort of almost like private, just us guys talking. Whereas, hey, if you write something, somebody might turn around and use that against you at some point, or you might say something that's wrong and then they could hold it against you. So I think there was almost this hesitancy of putting anything in writing, that some of these folks were afraid that it could come back and haunt you in a variety of ways. So it's funny that you say that, because that same thing that we all know now is such a benefit was seen almost as an overriding concern at the time.
I do remember fondly at Decker, there was one time where in a Second Circuit appeal, the plaintiffs that we were up against cited one of the firm's client alerts as support for the point they were making against our point. I think it was a bit of a stretch. I think it was just kind of attorneys trying to be a little bit clever and use their adversaries' words against them. It didn't really stick, but that's why I do think some law firms are very careful about what they write, and they run conflicts checks. And I've written about how you could run a conflicts check for your thought leadership content, because you can never be too sure. So I understand that concern. I'm not quite sure how often it comes up, but I could see that. Another concern is, well, gee, Rich, if you write so much, you're going to give away the firm's special sauce. And what's always funny to me is that what's special about a lawyer is not just their knowledge and wisdom they have about the topics generally that they cover and the area of law they practice, but how it's applied to a discrete set of facts, a particular set of facts presented by a client. And if you're writing an article about a recent Ninth Circuit decision or Third Circuit decision or state Supreme Court decision, there's a darn good chance you're not talking about any specific facts except those that are in the decision. And
Yeah.
and I think that's kind of like an old standby in terms of, well, let's not get too deep into our content creation efforts because we don't want to spill our special sauce. Well, guess what? Every firm has secret sauce, and guess what? When you have a client who retains you and your relationship is covered by attorney-client privilege, that's when the secret sauce comes out, not in the form of an article for a third-party publication or a blog post.
Yeah, yeah. And I mean, Wayne, what you're talking about here is some very, very intricate and important discussions that our firm had in very trying times in the opening weeks of the pandemic 2 years ago. We knew we had an incredible team of attorneys, cross-disciplinary, wage and hour, leaves attorneys, safety attorneys, benefits attorneys, all of whom could contribute and help employers through an incredibly trying time. And we were compiling just incredible, practical, detailed information about how employers could live day to day, because goodness, they were, things were changing and evolving, and new obligations and new standards and whatever. And so we made a conscious effort to place most of our content online for free. And there were some attorneys in our firm who were against that, who wanted to, I don't want to say in any sort of way like these are the same mentality of people who wanted to, charge for drinking water after a hurricane. I get it. I mean, they wanted to monetize the work that our attorneys were doing, and say, hey, why are we giving this stuff away? That this is the secret sauce in our firm. But the majority of attorneys and leadership in our firm recognized the value. They started seeing the value very quickly of our brand differentiation coming across, our firm getting, dozens, if not hundreds of new clients because they found our stuff online for free. It's the eternal debate, right, between giving away your content and selling it. And I don't have the easy answer, but I do know that in lots of instances, putting your content out there for free just really can help separate you and make a name for yourself.
Yeah, absolutely. And in our little world of legal content marketing and legal thought leadership, a lot of people look back at March 2020, April 2020 as a pivotal point in time where many law firms that were behind, even in 2020, that were arguably behind in content marketing and thought leadership marketing, realized very, very quickly the value of providing relevant and compelling content for free to would-be clients, to current clients, to referral sources, to the public generally. I have heard anecdotally that spurred a lot of lawyers at firms to be more interested in content marketing and thought leadership marketing, because then they saw the benefits of doing so for their resume, for their LinkedIn profile, whatever. And then as things got busy toward the end of 2020 and into 2021, things started to slow down a little bit. I'm curious, did the COVID-19 pandemic, especially those first few months, did that change the perception of content marketing and thought leadership marketing at Fisher Phillips? Because obviously the firm was progressive enough to have you in some publications role as early as 5-6 years ago, or I guess as early as four years before the pandemic. So I'm curious if the pandemic changed the way Fisher Phillips approached content marketing at all.
Yeah, absolutely, no doubt. And I mean, they say from crisis comes opportunity, right? And we probably all heard that too many times during the pandemic. But if it weren't for the pandemic, I feel very certain that I would not have the chief content officer role in our firm, because it did demonstrate the value, not only in terms of content creation, but the value of how content can supplement and really bolster our marketing efforts. So what it did is allow the firm to realize that amazing things can happen when you put the right people together in teams and have somebody whose main job it is just organize folks. Because every law firm out there has incredible talent and incredible attorneys and incredible thought leadership. What's hard is harnessing all that, right? What's hard is is teaming them together, knowing, hey, if this person worked together with this person, we could create a great piece. Or have somebody like me, or somebody like you ghostwrite a piece, but then take their expertise and add that expertise to it to make it even better, right? So I could write an easy piece about a new directive that just came down from the OFCCP or something like that, and I could write the nuts and bolts of it. But you then add to it our affirmative action attorneys who live and breathe this every day, who could then just talk to me for 2 minutes and or add to it and add their expertise to it. And goodness, all of a sudden you have a really outstanding piece. And so I think what I was able to do is be that sort of cat herder, right? I could take a step back. I didn't have the pressures of getting the 20 phone calls every day from clients who were going through this crisis or managing my litigation docket. I had the luxury of having that breathing room and the ability to see things in a bigger picture perspective, so that I could sort of direct people, be the air traffic controller in creating the content and getting it up quickly, and identifying the right people doing the right thing. So yeah, we were absolutely lucky that I had the I would say free time, because I didn't have free time per se, but I had the focus on making sure content was getting out every day, because these other law firms that had all that great thought leadership without somebody like me were left behind because they didn't know what to do with all that great thought leadership.
Well, that's a perfect segue into your role as Chief Content Officer at Fisher Phillips. I mean, there are some listeners who are probably wondering what took us so long to get to that. You have a unique title. I'm not aware of any other Chief Content Officers within the AmLaw 200 world, and probably not beyond that. Maybe someday soon, once they hear this podcast and they see the good work that you're doing and that Fisher Phillips is doing. But talk to me a little bit about what you, Rich, do as the Chief Content Officer at an AmLaw 200 firm.
Yeah. Well, it's hard to put percentages on it because every day is a little unique. But if you sort of segregate it into two pots, right? The one big bucket is the writing and editing. Every day I am bombarded in a good way with attorneys around the firm who either have ideas to write something or will send me drafts of things they've written. And so I review them and edit just about every piece that's on our website. I've reviewed and edited, and just make sure it follows sort of our style and our template, to make sure it's not too legalese, right? That we excise the lawyerly stuff and we include the practical stuff that clients want to hear about. I take the 1,500 word piece about every nuance that came through in a new executive order and slim it down to 600 or 700 words and just hit the practical meat, right? So they do a lot of the editing, do a lot of writing myself, where if I see a hole, I see that we need to write something, but the people in that area, whether it's a practice area, an industry team, or geographic area, just don't have the time to get to it that day, I'll write it for them, or and have them bless it and then get it posted. So the writing and editing is half of my job. The other half of the job is really managing projects for our firm that all relate to content. So it involves the creation and launch of different task forces that we know content can support. Where the content plays a big element in starting new groups. So I will help brainstorm with, in the last year, I can think of a cryptocurrency and blockchain task force that several attorneys, I started recognizing that this momentum was building, that people were talking about it, but yet we didn't really have a cohesive approach to it. So I helped sort of brainstorm and launch with that group. We have a great sports industry team led by several attorneys who were former athletes themselves, who wanted to harness all the other attorneys they knew were not only athletes, but represented sports industry clients. So sort of help them with that. So that's the practical stuff. And then the other stuff I have, again, it's the luxury of time that I don't have the client pressures on me that allow me to be able to do what I'm sure many attorneys wish they had the time to do, which is take a step back and breathe and spend some time forecasting what we think is going to happen around the corner and what our clients need to be worried about tomorrow. So we spend a lot of time brainstorming with our firm leadership, our chief innovation officer, our marketing and business development officer, just trying to imagine what are the things clients going to be worried about tomorrow, and what are the things we could be doing today to position ourselves so that we are addressing those needs before they even realize they have them. So it's a lot of, I don't want to say it's, a lot of philosophizing where I'm just sitting around thinking, because a lot of it involves spending a lot of time thinking, coordinating with different attorneys, and practice group leaders and professional staff leaders. But a lot of it is trying to figure out what's happening tomorrow. So yeah, I mean, that's sort of my everyday. And one thing we might be talking about this in a little bit, but I think it's important. One thing I realize it's important to say now, is a lot of the ideas that we come up with fail. A lot of the ideas we come up with just fall flat in their face. And I thought,
what does that mean, Rich? What does that mean, fail?
Yeah, I mean, sometimes conceptually we'll come up with an idea and we'll kick it around and we'll spend a lot of time on it and nothing will come of it because we realize there's not the momentum there. Maybe we don't have the right people in the right roles at the right time with the right skill sets, or the people who do have the skill sets just don't have the time or initiative or interest to take it on. Or we'll launch a project, a publication initiative, or a new piece of content, and we want to make it a regular feature. And we look at the analytics and it's just not getting any traction. We're not seeing people read it. We're not getting good anecdotal feedback. We don't really get a lot of investment from our attorneys in the firm who aren't excited about contributing to it. And so we just, we dismiss it and it's done. And that, again, when I think about the luxury I have of time to be able to spend foresight thinking of things, I also have the luxury of not necessarily, I don't worry about getting sued for malpractice anymore, right? I mean, when you're practicing attorney, sometimes your creative juice gets squashed because you don't want to do anything out of the ordinary, because out of the ordinary can get you sued, right? Out of the ordinary can make you lose a case. Hey, the way you ran this case, the way your partner ran the case 20 years ago, it worked. So why do it differently? And if you do it differently, the client might get pissed off at you if they lose the case, right? Or you're going to try something wacky and new, and if it fails, man, that could be a malpractice lawsuit. And so writing and content creation and what we do, it gives a lot of freedom, not only to me, but our attorneys, to try something. And maybe you're going to fail, and it's more like the corporate world where you got to have a lot of good ideas you got to have a lot of bad ideas to have a good idea. Attorneys aren't really trained that way, right? Attorneys are trained to play it safe, right down the middle, fastballs right down the middle of the plate. We're not messing around with new funky things. And I have the luxury of being able to try new stuff.
You're raising many interesting points there, and I want to mention one, then spring off to another conversation based on a second one. But the lack of creativity, I think, comes across oftentimes in the form of content that doesn't take a position, that is very much the traditional law school writing assignment from 1L, where you say, well, it depends, and there's this factor, and if you do this factor. I don't see very often in law firm thought leadership and content marketing taking a strong position. Now, obviously, some firms don't want to do it because it might piss off some clients. Fine. Some firms don't want to take a strong position because it might affect how they pursue certain cases down the road. Fine. But it's funny to me that I think some of that lack of creativity comes across in creating very generic content that, yes, explains what happened in a court case, and yes, maybe provides some additional analysis, but it doesn't get your attention or grab you by the collar because it's just right down the middle. It's not really compelling because it's not persuading you. It's just saying what is there.
Yeah. And I mean, that's a lot of what I get, right? A lot of the drafts I get are very much like that. Not only in terms of form, the Iraq, whatever, but also in terms of, you've read it and I'm bored while reading it and editing it, right? So how do you liven it up? And I'm not talking about, you also have to make sure you don't fall way to the other side of the sky is falling mentality. If you write every single piece as this is the most incredible thing and a significant development, and if you don't alter your handbook immediately, you're going to get, we can't go that route every single time too. Or with the proposed laws, goodness, every bill passed by the House or proposed by the House, if we wrote klaxon blaring alert every time the House passed a new law that would impact employers, people would stop reading our stuff. So what I have to do is find that balance, right? We have this really great series I'm really proud of right now. We're about to put out our fourth edition of it. We've done it every month so far this year, called FP Forecast, where we ask different leaders and practice groups and industry teams to take a look at these big picture things. What do you expect your clients to do if you're advising a general counsel who's about to run into their board meeting and give the board a forecast about what to expect in the next year so that the company can position itself? What would you say about these areas? And I have to. It's almost like I'm coaching them. Like, don't be afraid to take a position. Like, take that. They'll use some of that language. We may see this. Like, no, say you're going to see a litigation explosion. You forecast it. That's what you think. That's what they're wanting to hear from you. So making those bold statements sometimes are harder for attorneys because, again, we as attorneys are trained to play everything safe and include all this wiggle room. And a list of things includes this, which includes but not limited to, and all that catch-all language of and any other ideas that we may not have listed here. And content, to make good creative, compelling content, we need to take positions sometimes. And I try to walk that fence with them and get them to take that extra bold step. But sometimes attorneys just don't want to do it. So it's our job to recognize when to push and when to let it lie.
Lawyers love to talk about low-hanging fruit, and I am always surprised when lawyers, when it comes to content marketing thought leadership, ignore the fantastic opportunity that December of every year brings them to publish forecasting pieces about their areas of the law. And obviously some firms do this, but it escapes me why any firm with a blog regarding a particular area of law, why those blogs don't all have a predictions piece for 2022 or 2023. It gives lawyers a chance to be creative because they're going to be wrong. And if they're comfortable being wrong, which most of them aren't, but you're going to be wrong because there's no guarantee your forecast is going to be 100% accurate or 20% accurate. But this fear of being creative and this fear of kind of leaving topics and ideas on the table because we're too concerned about how we might be perceived if we're wrong or we're not creative enough. That's one example where every law firm should have a predictions piece. And if you do certain kinds of law, you can wait for different periods of time. If you are an education law firm, then talk about the school year and when school starts. That's your predictions piece. Or if you're a sports attorney or you're an agent or you specialize in something where there is a calendar that is different than the normal January to December calendar, well, that's your excuse to use that time as a way to discuss your forecast and your predictions. So I see it all the time, and obviously you see it in all of its forms with the attorneys that you supervise, but it is amazing to me the opportunities that are left on the table for lack of creativity and for lack of wanting to push the envelope and, heaven forbid, take a position on something.
Yeah. Well, and as I'm encouraging people to write for this piece and making them feel more comfortable with the edits I'm making, taking away these we might see to this is what we will see in the coming year, I tell them, like, for example, if I'm writing something this week, hey, think a couple of weeks ago when the baseball season started. If you were watching ESPN, you probably saw a panel of experts talk about who they think is going to win the World Series this year, who's going to be the MVP. In October, are you going to turn around and go back to these folks who made predictions and say, hey, you were wrong? I can't believe you were wrong about that. People recognize when they read it. Now, it's a little different, right? Because we're not just asking people to just guess if their team is going to win the World Series. We're telling people you might want to adjust your business practices based on our forecast. I get that. It's a difference. So we can't just be flippant about it. But goodness, we know that very few companies are going to go and radically, nobody's going to fire half their workforce because we tell them we forecast, a downturn in the economy in the coming year or something like that. They're going to adjust based on they're going to take it into consideration. It's one of the many factors they will use in their calculus of deciding how to act in terms of changing their policies and practice. So yeah, it's not people have this fear that that taking these positions are going to lead, predictions piece especially, are going to lead to somebody coming back at them a year from now and saying, you were wrong, but I've never heard that happening.
I want to turn now, Rich, to something that you mentioned before about creativity and freedom. And I'm curious, do you think that you, as the chief content officer at a firm like Fisher Phillips that focuses on employment law, do you think that you have more freedom or less freedom than your counterpart at a law firm with 17 different practices?
Wow, that's a great question. I mean, I'd like to think I have more freedom than a colleague who's at a general practice firm with lots of different areas because, it's great that our firm has a singular focus, and it's great that all of our oars are rowing in the same direction, and there's no real competition between, departments or practice areas about which competing for resources or demanding time or whatever. Now, our firm certainly has many different practice areas and industry teams, and there are some attorneys in our firm that have, a real discrete practice like benefits or immigration that wouldn't know a courthouse if it fell on them, right? But by and large, our firm has folks who handle lots of different aspects of workplace law. So because of that, I think it's really great to have sort of everybody on the same team such that they recognize the value of what we're doing and how we move in a concerted effort in those ways. And in fact, there's so many opportunities to cross collaborate that will end up, rising tide raises all boats sort of thing, where if we wrote a great piece the other day about the intersection of an interesting solution for hospitality employers and how a certain wage and hour matter can be approached in a different way to really bolster and help them, and not only help them, but help their workforce. So that was just a great collaboration between attorneys in those two different practice areas that, I don't know, at a general practice firm, it might be a little bit more difficult to get the mergers and acquisitions team on board with the construction defect team, let's say, to collaborate. I'd like to think there's more freedom, but I also lead a bit of a sheltered life, so I'm not really sure what colleagues are doing in my same role at GP firms,
Yeah, and I think it's a natural. There's some natural skepticism about niching down. Like, gee, think about all of the clients who are turning away by not doing that kind of work. But I think what you find is the opposite. And most people anecdotally will tell you they've gotten busier, whether they're an attorney, an accountant, a chef, whatever. They get busier and they generate more business when they pivot and they niche down, because then you can be recognized as the leader in something very specific. And it's just like if you are a client looking to seek legal counsel, do you go to the law firm that does estate planning, criminal defense, personal injury, and family law, or do you go to the law firm that does medical malpractice? Well, obviously, I think the answer is that. So I think niche is obviously medical malpractice. So when it comes to corporate law firms, I think clients are smart enough to say, well, holy crap, Fisher Phillips, this is what they do. Like, they do employment law and they specialize in these various aspects. They're quote unquote practices, but they're still employment law. They have to be the leader, right? Because they specialize in it. They know the ins and outs. And oh, by the way, they have this robust content program where we can learn so much about what's going on in the law by looking at their blogs, their articles, their podcasts, etc. So yeah, I think attorneys are pretty much now familiar with the idea that there are riches in the niches, and that once you can become an authority on a particular topic, you are likely to see more success than being a general practitioner covering a wide range of law. Let's talk about the process for content creation at Fisher Phillips, because having a chief content officer on board suggests to me that there is some structure and some formal processes in place for the creation of content. And I was wondering if you could walk us through the content creation process. Where do topics come from? Are they assigned to associates? Are attorneys expected to just present articles and start writing, and then you're the one who decides if they should be published? Talk to me a little bit about the way it works, and please, as the former Big Law associate in me, would love to know, do attorneys get billable credit for any time they spend?
Yeah, I wish, not billable credit, but they do get credit. And it's interesting. I mean, by the time you air this podcast, our system may have changed, because I am absolutely delighted at the fact that starting very shortly, I'm going to be doubling my team size. The content department at Fisher Phillips is going to explode from one person to two people. I've hired a legal content counsel who's going to start and help me. And we had to figure out, in terms of how not just the cadence is going to flow differently with me having finally some resources to assist, but how this is going to change the very process, all those questions that you ask, because we're going to embark a new territory here. But where it looks right now is it's an interesting combination between us identifying topics to write about and folks writing about them on their own. I'm proud of the fact that we've created an incredible culture in the firm in the last 5 years, where attorneys don't need to be spurred by me to be able to write stuff. They feel, I don't have to reach out and beg them. There are a lot of folks who, on their own initiative, identify topics and recognize the value that writing is going to give to them, and therefore just spontaneously offer to write things. So that happens a lot. Where the magic really happens, though, is we very intentionally, in our firm's vision statements years ago, we really recognized that our practice areas and our industry teams are not just collections of people who happen to handle wage and hour matters, or some people who represent healthcare clients, that these need to be active engines of the firm in terms of bolstering our strength, collecting our knowledge and our expertise in these areas, but also from a marketing perspective, create content that relates to these areas and fields. So a lot of where the magic happens is me coordinating with all the leaders of our practice groups and industry teams. So if we identify this morning, let's say, a wage and hour matter, I'll reach out to the two co-chairs of our team and say, this looks like an interesting topic, let's talk about it. They, because they're with their groups on a daily basis, know that an associate in New Jersey, let's say, has just recently identified that they want to write about something, or they want to be more involved. Or we have somebody who's a former attorney in the Department of Labor who handled these kinds of matters when they were there. Let's bring him in. Or we have a former official for the Department of Labor who used to handle this sort of stuff as well in her day. So let's bring her involved. So they know the people who might be brought in well. And then sometimes I have to do the big cattle call, right? I have to send the all associate email or the all group email saying, hey, we're looking for somebody in this time frame to write on this topic. What do you think? And we'll identify new people or people who have time and availability. So a lot of it stems from sort of coordinating through people. I couldn't just do it all myself, or else I'd be sending all attorney emails on a daily basis, and people would want to strangle me rather than work with me. And our attorneys, our associates, and our partners, they have no expectation ever of writing for the firm. But I'm proud to say that last year, of our about 500 attorney headcount, I think the last number I saw was that in 2021, we had 240 attorneys who contributed to content at some point. So about half of our attorneys wrote at least one piece of content, many of whom wrote multiple pieces. So they even though there's no requirement for them to write, anything they do writing for the firm does count towards a non-billable expectation that all of our attorneys have. So all of our attorneys in our firm have a contributing non-billable requirement. And it's different for each attorney in the firm, from the most junior associate to the most senior attorney who also happens to be regional managing partner, let's say. They all have varied requirements to the contributing non-billable requirement, but they can fulfill those hours through through the process of writing. So you do get a lot of people near the end of our performance year who might reach out to me and say, hey, I'd love to write something in the next couple of weeks because I need to fill that time, which is great. And I love that. But we get people who recognize the value of it all throughout the year too.
That's a fantastic participation rate. And you may have just made a number of in-house marketers and business development folks at law firms along the size of Fisher Phillips just fall over or know what to wish for the next birthday wish. That's incredible. Almost 50% contributions, especially when you've got so much work for these attorneys to do in this current era.
Oh, yeah, absolutely. And one of the things I do, I host a quarterly meeting of every new attorney in the firm. I invite every new attorney, and a firm of our size, we add dozens of people each month. So these meetings are fun for me to meet people, and I just share with them. I spend an hour preaching the gospel of publications, talking about how it could benefit their careers, whether you're an entry-level associate or a lateral partner with 15 years of experience and a massive book of business. I talk about what we do with the firm and how our writing could help. And I go over a little bit sort of the mechanics of writing and some tips about writing as well, how it's a little different than legal writing. But a lot of what I do is just evangelize about our firm's writing. And I really think it's made an impact. That's helped build this culture, because attorneys from the earliest days in the firm will realize, hey, this is a firm that cares about writing. So while they're never forced to, I really do think those meetings have helped engender this sense in them that, hey, this is something I want to consider for my own personal marketing plan.
Is there any additional training that you or your colleagues give as part of that evangelizing? Because you and I, and I'm sure other people, take for granted that thought leadership content and content marketing generally for law firms, we take for granted that we can kind of see the entire process, and we can start with the identification of an idea. We can determine who the audience is, where this piece will go. We can write it, we can edit it, and we can give it to whoever is the final decision maker and say, here is this packaged, polished piece of content, go run with it. But most attorneys who are balancing 2,000, 2,200, 2,500 hours of billable time each year do not have the ability to see the process through. Some might be great idea generators, but not great writers. Some people might be great writers, but they couldn't find the time or they don't have the ideas. I'm curious, is there training available that can help junior partners and senior associates or any associates get a better feel for what it is like to effectively create compelling content?
Yeah, we have an informal system in place now, but there'll be a more formal system in place soon. My hope is. So the informal system is a combination of on-the-job training and one-on-one feedback sessions with me. And by that, I mean, I encourage folks, and this is the way I was trained as a young lawyer. And that is, I was probably thrown into the deep end earlier than I could have before I really knew how to swim. And it built my character, right? It gave me a lot of confidence knowing that attorneys who supervised me thought I was ready for this stuff when I didn't think I was. But I give, besides these sort of intro sessions where I give them some pointers, when somebody's about to write something for the first time, I give them a little bit of feedback or a couple pointers, not a lot. I let them run with it on their own. I encourage them, if they want, to review our current stuff and say, hey, sort of follow the template there. You can't go wrong that way. But I also I don't want them to just mimic other people's voices, right? I want them to find their own voice too. And so they'll send me their first draft. And I have a very common email I write back that says something like, when you open this red line back for me, you might think I did radical surgery on your piece, but don't worry, it was great. And here's what I did. Because mostly what I'm doing is taking their content. 95 to 99% of it is just fine, but I'm shifting the focus of it. I'm hitting maybe the high point a little quicker. I'm reframing it so it presents more of an interesting, practical lesson for employers that they actually can learn, as opposed to just a recitation of the law. I do that stuff. And I usually and I tell them why I made the changes I do. I usually sometimes will talk to them on the phone as well. And it's amazing to me how the second or third time they're writing something with the firm, it's really taken on new character, and it doesn't really require that deep dive anymore. So that's what I do with them currently informally. Now, formally, and so I call those quarterly meetings I have with new attorneys Publications 101, where I just sort of tell them about our firm publications. Once we have our new legal content counsel in place, it's going to free up a little bit more of my time. And it's been a longstanding wish of mine to unveil Publications 201 sessions, where for those attorneys who do writing a little bit more often or who want to spend a little more time learning how to write, we will have some classes with them and maybe some formalized one-on-one mentoring with them to help them on their individual writing plans. So if any Fisher Phillips attorneys are listening to this, stay tuned, because great stuff's in store for them, I think.
Well, I hope you don't do what law professors and undergrad professors do, which is when they create a new class, they write the textbook and they create an alternative source of income for them, because they sell the textbook as the prerequisite book for the class. So let's hope there's no Publications 201 handbook for $300 hardbound.
Behind a paywall, right? I'll have them send me some Venmo to get access to it, perhaps.
Well, all joking aside, I think you are also doing attorneys a favor when you proof their work, when you polish up their work and they really learn from it. They become a better writer, not just for thought leadership and content marketing purposes, but they can become a better writer for their normal, quote unquote, normal legal writing. When you are used to the normal mediocrity of opposing counsel's letters and briefs and motions, it is like a bright light when you get a letter or a motion or a brief that is so well written because it's not conforming to the normal legalese standard. It is actually readable, and they might be scoring points against your clients, but damn, it's actually enjoyable to read. You don't feel like you're just kind of trudging through it. You actually are, it's being digested pretty quickly because it's easy to read. So you're doing your colleagues a favor, and I hope they realize it, that the skills they're getting from you and the techniques they're getting from you, they can apply to any writing they do, whether it's content marketing or the next motion they write.
I've dipped my toe occasionally in helping associates who reached out to me with their legal writing. I mean, it's not in my job description at all, right? But I don't say no to people if they want help with writing. And I often will encourage them to take similar tacks, like take a big step back. Why is it that your first paragraph of this position statement or brief or whatever it is has to go through the whole, comes now defendant ABC company paren ABC and paren with its motion first, as opposed to like first sentence, this case should be dismissed because the plaintiff kept falling asleep at her desk, and that's completely unacceptable, or something like that, right? Where just get right to it, make it interesting, make it compelling, make it a story that you're going to want to read. I want to continue to read that after I hear that first sentence. Wait, tell me more about this. This is interesting. I think a lot of attorneys are, first of all, scared to do something a little different and a little punchy and a little creative. And I think the biggest impediment, though, I'll be quite honest with you, is an associate might take that leap and might write that creative brief, and then they send it to their partner for review, and that partner is scared because they won't admit they're scared. That's not the way we do it here. I've always written it this way. I don't want our position statement to stand out. I want it to be very, legally formalistic. And I hope that a lot of this is a sort of a lifelong pursuit, right? That a decade from now, these associates I'm helping to write will be the partners that will encourage their associates to write a little bit more creatively on the legal side as well.
Yeah, and that's a trickle-down effect where those associates become partners next year, in a couple years, and then they have a whole new context, a whole new prism through which they look at their legal writing. And it might be closer in line with the content marketing and thought leadership marketing in terms of clarity, in terms of creativity, in terms of it being brief and punchy. And now you've slowly transformed the culture of the legal writing at the firm by helping to improve the culture of the marketing and business development writing at the firm.
Yeah, that would be amazing to see. I would love to hear. I mean, I hear, obviously one of my favorite parts about the job is hearing these anecdotal reports or getting an email forwarded to me from a client who tells their attorney, man, I loved reading this. This was great. I always turn to Fisher Phillips stuff. And it's always written so well. And you really helped me understand this. Thanks so much. I'm waiting for the day that I get somebody saying like, hey, I tried your creative whatever in some legal writing, and here's the result I got, or I got this great piece of feedback from whoever. That would be great. That would be great. One day maybe.
I'm sure I'll be here before you know it. I want to end with your predictions and observations for content marketing and thought leadership marketing trends for the legal industry coming up. But I'm curious about one tactical issue that comes up often when it comes to reporting on developments in the law. And that is the tension between rushing to be the first or second law firm to publish a client alert regarding a relevant case decision or administrative agency action versus taking a little bit more time to include some more thoughtful commentary and analysis. I'm curious where you come out and where your colleagues come out.
I would say my position has evolved on this over the years. I used to, especially when I first held this job, you hold a job like publications partner and you feel like you need to justify your existence every single day. So part of the way I felt I needed to justify my existence was being the first out of the gate on anything. God, we got to get our thing up and out before our competitors do, because, oh my God, if our client gets something from a competitor first before us, they're going to hire them. That was the thought, right? I'd like to think that our firm has differentiated or become a differentiator enough in that our content has a reputation for being cogent, for being practical, for cutting through the digital clutter, such that even if a client's not necessarily waiting by their computer at the moment, waiting for the Fisher Phillips alert to come over their email. I get it. They're having a busy day. They're probably not going to get to this stuff till the end of the day. I don't think they're necessarily just going to click on the first one they get. They're going to click on the one that they know is going to present them with the information in the way they like to get it. So I'm not as firm anymore, dogmatic about we've got to be the first out the door. I think there's obviously a timeliness element to it. We can't get it out a week later. But I don't feel the need for us to write the same thing that CNN is going to write about. So a great example is the transportation mask mandate that just got knocked down by the court. Rather than rushing it out that same day, and what are we going to say that's different than what somebody's reading in Washington Post or New York Times or wherever they get their news from? Let's spend a little time. Let's have the experts in this field within our firm who know what they're talking about, spend a little time collaborating with me, forming their own opinions, maybe talking to clients to figure out where the pain points are in this that they're confused about, or where the rubber's really going to meet the road. And now we could write this a little more practically. We could provide the considerations that employers are really going to care about. So I'm certainly not in the camp anymore of we've got to be first out the gate, because I do think readers discern quality over just expediency. And I think that's really helped us a lot.
I totally agree with you. And I don't think any law firms should take on the role of a Law 360 or a Bloomberg Law or a Reuters, where they are covering breaking news in the form of their client alerts. I actually think that law firms would be smart to do a two-step process, which is, if you think about client alerts, the value is both with the analysis of the legal development, but it's also informing the client that something actually happened. And right. I'm wondering if there's a smart enough law firm out there that can say, all right, we're going to do this in two parts. When a decision comes down, we're going to blast out within like an hour. We're going to do a 2-paragraph email that says, you should know that the Ninth Circuit just released this decision that concerns, contractors versus employees. And our attorneys are looking into it, and we will be providing more robust analysis. But at this point, it appears the Ninth Circuit, XYZ. And that's like a 2-3 paragraph email that covers one of those two goals of a client alert, telling your client quickly that something happened in the world of law that they should know about and that might be relevant to them. And then a few business days later, you could have your 1,500-word client alert that dives deeply into that. I'm not sure anyone will dare do that, but I think that could cover the bases. You're getting out early, but you're not putting the burden on your attorneys to be smart and analyze the decision at that moment. You give them the normal breathing space to be thoughtful and creative, but you still tell the client quickly something happened.
I love that. And there have been times we've done something like that, not exactly, but very similar, where we do the initial alert and then follow up with a little bit more once we've had some time to think about it. But sometimes that follows 2 or 3 days later, even. Yeah, I mean, it's a great point. I think we also have to recognize where we stand. We're not journalists, right? We're not breaking the news. I did get frustrated sometimes early in the pandemic when, I don't know, let's say, just going to pick this out example because we don't have an office there. Oklahoma passes a new public health order that allows restaurants to now seat people indoors. And I'd get an associate who'd write an alert for me, and it would essentially say that, and it would just cover, like, in detail the steps the restaurant would need to take to comply with this public health order. And I always think to myself, well, I would publish it because I didn't want to, turn them down when they write something for me. But I'm pretty sure this restaurant knows this happened, right? I don't think they're waiting for the Fisher Phillips alert to know that they can reopen their business, right? This is something they're hearing about on the news or from their hospitality association, or the public health agency locally. So there's always that fine line between deciding, like, who we are and what our mission really is here, right?
Yep. And I think you have to know who you are and know what your clients look to you for. And there's a darn good chance it's not to break the legal news. It's to analyze the legal news and let them know how what just happened could impact them and what they need to do because of that.
Yeah. Now, what's fun, though, is when we've anticipated something's going to be happening, we've pre-written the alert that does include the analysis and sort of the steps of, like, what you need to do about it. And then the minute the decision comes down or the order gets released or the law gets passed, we're able to send it out right away. Those are pretty cool when we get, like, the feedback from a client saying, oh my goodness, I can't believe you got this to us so quickly and it has all this information. So it is pretty cool when you could do it that way, but it's rare. We don't do that all the time because it's not necessarily feasible, but it's fun when we can do it.
Well, Rich, a content magician never reveals their secrets. So
Right.
you
Well,
just
hey,
did.
good luck to those out there who want to pre-write alerts about how every decision's about to come down.
Rich, this has been a fantastic conversation full of insights. And before we go, I'm hoping you might be able to opine from your perch in the Pacific Northwest and with your finger on the pulse of legal content marketing and legal thought leadership, what you see coming around the bend in terms of trends for lawyers, for in-house marketers and in-house BD folks. Where do you see legal thought leadership and legal content marketing going in the next couple of years from a corporate law firm perspective?
I can think of a few things. Number one, it's going to continue to be more condensed, right? I mean, people are used to consuming their information in bite-sized chunks. The day of the 3,000-word newsletter summarizing a case and going over the concurring opinions and the dissents is long gone, right? And so I see us getting even shorter and more brief, and perhaps presenting the information in ways that they're used to seeing, whether that includes, how people consume news on their phone or, on social media videos. I'm not saying I'm going to be doing any TikTok dances related to the newest Supreme Court ruling, but, we're moving in that direction, number one. Number two, I think it's going to get more curated. I think people want to see information that they care about presented to them in a way that's bespoke for them, right? That hits them in at a time and in areas that they care about, and with the extraneous stuff somehow not included. But number three, I think with that comes the natural tension is going to continue as we get more and more specific, and we get more curated. I'm really be curious to see over the next 2 to 3 years what happens with the selling of content, of whether a price is put on some of this content. Just as 20 years ago, maybe the thought of getting any content, paying for any information on the internet is insane because everyone just offers it for free. And now anyone who consumes content out there has several news sources that we pay for. I wonder if we're going to be heading in that direction too. It'll be a fascinating look in the next few years to see where we go in that realm.
I'm right there with you. I think content as a product is a fascinating idea, and the question becomes, what does that product look like? Are we, the law firm, providing data that we had some proprietary way of extracting that is relevant to our target audience, and now we're going to give you access to it on a monthly basis for a subscription of who knows, $10,000 a month or whatever? Are we going to provide a deeper level of analysis in terms of legal developments and charge for that? Are we going to do some kind of subscription video or subscription podcast? I shouldn't say all of the, there are many platforms out there that support subscriptions. Substack, now Apple Podcasts, Spotify, all of these different platforms allow a free stream, if you will, of content and a paid stream of content. And I think there will be enterprising law firms, corporate law firms, that understand that the content they create could be even more valuable to their clients, so much so that the clients will be willing to pay for it if the law firms were a bit more creative in the content they were creating, the data they were pulling, and perhaps even more niche. Like, we're not just going to do this for venture capital clients. We're going to do it for venture capital clients who focus on biotech or who focus on green energy. And then not only, of course, can you niche it down and target those audiences, but you become known even more as an authority in that space because look how finely tuned the product is, the content is for that audience.
Yeah. So, it's such great points, and it'll be a real differentiator, I'm sure. And being on the vanguard of that sort of initiative will be a fascinating place to be. So I'm sure you and I will have many interesting conversations about it over the coming years.
We'll stay tuned for more developments on that end. Rich, I appreciate your time. You've been so thoughtful and so generous with your time. If anyone who's listening wants to get a hold of you, wants to chat with you about you being a chief content officer or any aspects of thought leadership and content marketing for law firms and lawyers, what's the best ways for them to contact you?
Just go to fisherphillips.com, our website, and look for the long last name that's hard to pronounce and hard to spell, Meneghello, and connect with me there. I'm also on Twitter. I'm very active on LinkedIn and Twitter. LinkedIn, obviously, my last name, and Twitter, my handle is PDX for Portland, PDX Labor Lawyer. Okay, that's a distinctive and niche Twitter handle. Congratulations. Were you early on Twitter? Yeah, probably been 10 or 15 years. It was early in the day, back when Twitter was, not that it's not the wild, wild west now, but back then it was a little more, even more interesting, Yeah. Well, I think that's when people were still posting like, just had lunch or out for my run. It wasn't the, I don't want to call it a cesspool, but it wasn't the marketplace of ideas that it currently is today. Yeah, it's a great place, a very polite way of describing Twitter, Wayne. All right, Rich, thanks again for your time, and I'll be talking to you. All right, thank you. Well, that's a wrap for this episode of Legally Contented. Thanks so much for tuning in. Check out the episode show notes for more information about our guests and for links to resources that we discussed during the episode. We'd appreciate your feedback and recommendations for future guests. Email us at hello@legallycontented.com, hello@legallycontented.com. We would appreciate if you told your colleagues about this podcast, if you subscribe to the podcast and urge them to subscribe as well. And while you're at it, maybe you could even rate and review the podcast on your favorite podcast player. Until next time, thanks so much for tuning in to Legally Contented.